Our webinar on IR35, how status is determined. My name is Andy Chamberlain. I'm the Director of Policy at IPSE, and I'm going to try and turn on my camera so that you can see me as well as hear me, I hope, and also see the slide in front of you. I'm joined by my colleague Ryan Barnett, Economic Policy Advisor at IPSE. Are you there, Ryan?
I am, yeah.
Hi, good to see you, Ryan.
Yeah.
What we're going to do today is rattle through the fundamentals of IR35 status, and we're going to talk about the case law, because the way that we work out whether IR35 applies or not is to look at the case law, which means each case affects the outcome of the next one. So we'll see what's been happening there. We're going to look at the main factors which determine status, which are personal service control, mutuality of obligation, and then the secondary factors as well. And we're going to talk a bit about the check employment status for tax tool, which, as many of you may already know, we don't like very much, and because it doesn't compare very well to how we should really be determining status. We would like you to ask questions, and I'm going to go through, I've got a lot of slides to get through, but we're going to go through them pretty quickly so that we can have time for your questions at the end. And if you could just let us know that you can see us and hear us okay as well in that questions box now, that's always reassuring to know. So just so you can see and hear us, that'd be great.
I'll be going through them whilst Andy goes through everything, and if anything specific pops up that is relevant, I might butt in occasionally, but I'll probably have my webcam off and come in at the end with a big block of questions, hopefully, about some of this stuff.
Perfect, thanks, Ryan. Yes, and particularly if I say something which people think doesn't sound right, then let me know and I can correct it straight away. But hopefully I do know a little bit what I'm talking about on this particular topic. Okay then, so just before we get going into all that, let's just update everyone. As many of you will already be aware that there are changes due to come in next April, this coming April 2021. They were delayed. They were supposed to come in this year. They were delayed because of the pandemic and other things. There was also a House of Lords report which was very damning of the new rules, which we fed into, gave evidence to that committee. Unfortunately, the government sort of ignored most of the recommendations in that report, and the Finance Act, which contained the new legislation, has received royal assent. It is law. That happened this summer. There was an attempt to amend the finance bill, an amendment that we supported, which would have delayed it for a further 2 years, but that unfortunately did not carry in the House of Commons. Now, the other thing that is quite recent, and some of you will already know about this because I've written a blog about it, and it's been increasingly talked about here and there, but perhaps not everywhere, is that there is an error in the legislation. So this legislation, which has now been passed into law, we've now realised, or HMRC has now realised, that there is a problem with it. And it's all about who the intermediary is. It's all quite technical. I'm not going to go into it too much here. But HMRC has last week confirmed that they are going to have to put forward new legislation, the next finance bill, to correct this. So it's not quite dead. They are going to have to come back and pass new legislation to correct it. I don't think that this, unfortunately, is going to lead to a further delay or the whole thing being harpooned. I wish it was. But just so you know, we are continuing with our lobbying against this. And we did last week write to Lord Forsyth, who was the chairman of the House of Lords committee that wrote that report in the second bullet point, and said, are you aware that there's this problem with the legislation? There's a statutory instrument which has been put to the Houses of Parliament, which deals with the NICs, the National Insurance Contributions element of the legislation, which contains the same erroneous wording. And he has tabled a humble address and is saying that it should be annulled. Now, I don't think this is going to necessarily mean, no, that's it, then the whole thing's off. I think that's unlikely. HMRC knew they'd have to come back and address the SI as well. But it's just so you are aware, we are doing things behind the scenes and talking to our contacts within Parliament to try to make sure that where there are problems with this legislation, and it is littered with problems, then we're letting people know about that. So, you know, watch this space, but we must prepare for the change coming in. It is, the government is intent, unfortunately, on it coming in, despite all the arguments against it that we've put forward, and we will continue to put forward. Okay. Let's go back to the basics then. You know, what is IR35? What's it all about? Well, basically, it's all about preventing disguised employment. And that's where someone acts like an employee, but they disguise themselves as a company to reduce the tax that they and their clients pay. That's what the government say. That's what a disguised employee is. In other words, rather than just paying tax like an employee, you pay tax like a company, and there can be a tax advantage doing that. IR35 is just a nickname for anyone that's interested in this stuff. It was the 35th press release issued by the Inland Revenue for the 1999 budget. So Inland Revenue IR35, and it just stuck, and everyone refers to it as IR35. It was formerly known as the intermediaries legislation. And recently, what we talk about a lot is the off-payroll working legislation. This is what the government use, but they'll often say off-payroll working brackets IR35 legislation. In fact, there's two bits of the legislation. So the initial IR35 legislation, which is the one in the private sector that still applies right now today, that's Chapter 8 of the Income Tax Earning and Pensions Act. When the rules changed in the public sector a few years ago, that became the new Chapter 10. And the changes coming in April is all about updating Chapter 10 so that it applies to the private sector as well. So to be technical, you could say IR35 is Chapter 8, off-payroll working is Chapter 10. But for most people, it's all IR35 really. The government tried to explain what IR35 is as well, and they do a pretty good job here. I'm not going to read this out, but it's there in the slides, and you will be sent a recording of this webinar as well. So you can look back at it at your leisure, but that's I'll give you a second to read it. That's what it says in their guidance, which is sort of clear, but nothing about IR35 is ever that clear. That's the trouble, as we're about to discover. Now, if it's the intermediary legislation, then what is the intermediary? Well, essentially what it's all about is if you have a person, a worker, an individual working for a client or organization, there is something in the middle of them, that's the intermediary. And most of the time when it comes to IR35, we're talking about that intermediary being a limited company. Sometimes these are referred to as personal service companies, but that's a problematic term. There's no legal definition of a PSC, but you will hear that phrase used a lot. Well, that's a PSC. Well, it's the same as any other limited company, actually, legally. There's no difference at all. So it's a difficult thing, but that's what the intermediary is all about. It could also be if you're working via a partnership, it could apply there, or even another individual. So if an individual in the supply chain is providing services via another individual and the payments are flowing through that chain, then IR35 could apply in that instance as well. But mainly it's all about limited company contractors. Funnily enough, this term intermediaries is the problem with is where we ran into problems with the legislation, because it's began to be used in the legislation for being almost anything in the supply chain. So it could be an agency, it could be an umbrella company, it could be a limited company, it could be an individual, and working out exactly who the intermediary is and where the tax should be deducted is where the problems lie in this era. So yeah, we will be keeping you all informed about that problem. And if you do get IPSE's newsletter, you might see an update from our CEO this week, which the newsletter goes out on Fridays. You might see an update from our CEO, Derek Cribb, on this issue. It's always been contentious and controversial, IR35. There's quite a few people like me out there who have kind of built a career around the controversy and the controversiality of it, because is that a word, controversiality? I'm not sure, probably not. it's so difficult to work out, and it causes so many problems and so many arguments that a whole industry has cropped up around sorting this thing called IR35 out. It's too complicated. That's the main problem with it. People say that it's unfair, largely because it is so complicated, and also because the way that you're asked to pay tax when it's deemed that IR35 should apply isn't necessarily fair, because the individual also has to pay the employer NI contribution aspect of it, or that's bundled into the deemed calculation, as they say. It's very disruptive to business. You know, trying to work out your IR35 status while also trying to run a business is not easy. And IPSE, we used to be called, as many of you will know, PCG, or the Professional Contractors Group, was formed in 1999 directly to oppose IR35. That's when it was first mooted in the budget, in the Inland Revenue 35 press release was in the 99 budget. And IPSE, or PCG as it was then, was created in direct opposition to it. HMRC has lost a lot of IR35 tribunals. They've lost more than they've won, which just goes to show you how difficult it is. They put a huge amount of effort and resource into bringing these cases to tribunal, and they get there and the tribunal says IR35 does not apply here. So it clearly isn't straightforward, and you could argue that even HMRC don't understand it. Or it might just be that no one really understands it. There's always another side to the story with IR35. Okay, so how do we work out when it does apply then? Where do those arguments rest? Well, it's built on case law, as I said earlier. So it's built upon precedent. The outcome of one case can influence future interpretations of the law. Generally speaking, the first tier tax tribunal does not set precedent. But when it goes higher up in the courts, if someone appeals it and then we get something at the upper tribunal or even the Court of Appeal, and there are some cases, with one case which is heading that way at the moment, that will set precedent and that can change the law. So if a higher court says, well, actually, we've decided that, you know, because of whatever factor, this is either caught or not caught by IR35, then that will mean that everyone in the future should consider that judgment, and that becomes a material consideration. You might hear phrases like the hypothetical contract. The idea of this is that a tribunal, if presented with an IR35 case, they will look at the written contract, but then they will put that to one side and they will examine what they can of the actual working arrangements, and they will build a hypothetical contract based on the real working arrangements and judge IR35 status on that. That's what that means. So it's not just about the written contract. The written contracts are important, and you should make sure you've got a good one, an IR35 friendly one, but it's not the be all and end all at all. The working practices actually are really where it's at. That's how we can determine whether IR35 should apply or not. It works on an engagement by engagement basis, and what we mean by that is that you as individuals are not IR35 caught or operating inside IR35, but one of your engagements might be IR35 caught. In other words, you might have two engagements, and one of them will be caught for IR35 and the other one might not be. So it's not about, oh, I'm inside IR35 or I'm outside IR35. It's about the nature of that relationship inside each engagement. Phrases like caught by or inside, I think you can tell from the way I'm using them, what they mean is this caught by IR35? Does IR35 apply to this engagement? Is this inside IR35? Does IR35 apply to this engagement? These are just some of the terms that you hear. And one final thing to make note of, and I will return to this issue at the end, office holders. If you are deemed to be an office holder, then you are automatically employed for tax. In other words, IR35 applies basically straight away if you're an office holder. An office holder is usually a company director, someone who sits on the board, something like that. I will talk a bit more about office holders in a bit. Okay, I know I'm going quite quickly, but I sort of have to get through this. But if there's anything that you want to ask a question about, do please. And I'm going to leave time at the end to return to some of these things. So there's one case which is referred to as the seminal case on status. And it's an employment status case, but it's also used for tax status and IR35 status as well. And that's ready-mix concrete. Ready-mix concrete goes all the way back to 1968. And it was here that the judge set down the main factors which we should consider if we're going to say this is like an employment. And they are personal service, sometimes referred to as substitution, mutuality of obligation, sometimes shortened to MOO, and supervision, direction and control, sometimes just called control. Let's look at each one of these a little bit more in detail. So substitution or personal service. Is there an obligation on the individual, the worker, to perform the work personally? If there is, if they can't send a substitute, then it points to IR35 applying, or it points to this is more like an employment. If they can send a substitute, and they don't have to actually send one, they just have to have the right to send a substitute, then IR35 does not apply. So is it a silver bullet? You know, can you send a substitute? Yes, I can. Fine. IR35 doesn't apply. Well, not quite, because HMRC are quite into this word unfettered, which you can see there. So if you have to go to your client and say, now look, would it be okay if I send a substitute? It would really be helping me out. And they say, possibly okay, maybe all right then that's not an unfettered right. You should be able to simply say, I'm sending a substitute next week, and they go, okay. And of course, in reality, things don't really work like that. But if you imagine I always use this as an example for some reason. In our office, the office that we haven't been in for months on end, we have water coolers, and we have a contract with a water cooler company. It's a limited company. And every now and again, someone from the company has to come in and tinker about with it and service it or whatever, and then they go away again. And one month it might be Steve, and the next month it might be Bob, and we don't care if it's Steve or Bob. In that instance, there is no obligation on any individual to perform the work personally. We have a contract with a company, and they send whoever they see fit to do the work. That's kind of how, in a way, substitution should work. That's how the revenue would see it. In reality, of course, the client is going to want to know that the person that you're sending as a substitute should be, equally qualified as you, able to do the job, not a lunatic, etc., etc. That shouldn't actually impinge on the right to substitute, though HMRC would probably take a different view. But I believe that the case law shows that they have a right to make sure the person's qualified, but you still have the right to send that substitute once those basic conditions are met. And I think that still means you have a right to substitution, and that should still mean that IR35 should not apply. And I think in most cases a tribunal would agree with that. The interesting thing about personal service is that it's actually in the legislation as well. So here's that chapter 8, which I mentioned. This is right at the front of the legislation. It says this chapter, in other words, we don't have to consider this unless an individual, the worker, personally performs, or is under an obligation personally to perform services for the client, right? So in other words, whereas the other things we're going to talk about are all about case law, this one's actually in the legislation. So try as HMRC or others might do to say, oh, well, substitution, people put a clause in their contract and we shouldn't really consider it. It's actually in the legislation, so you have to deal with that. Okay. Mutuality of obligation, or MOO. MOO is difficult to define, and its definition is heavily contested. HMRC have recently taken quite an extreme view. I would say it's quite an extreme view, or extreme interpretation of what mutuality of obligation means, and many others, including us, sit somewhere else on that spectrum of what it could mean. Broadly speaking, in any contract, there's an obligation on the parties to do something for the other. But in a key case on this, Carmichael versus National Power, it was decided that in order for it to be employment, there must be an irreducible minimum of mutual obligation to provide work and to perform work. In other words, if the client offers you some additional work that's not in your contract, you should be obliged to say, yes, I have to do that work. And likewise, they are obliged to offer you work if, say, you've completed the work that's in your contract. That's what we think mutual. That's probably the safest place to start from if you're considering what MU means. Mutual. I don't really like saying MU. I should just say mutuality. Mutuality in ready mixed concrete is there as well. And here they talked about, was there an obligation on the employer to provide work and a corresponding obligation on the employee to accept and perform it? And that's where we go back to. So we've had two key cases which makes this point about mutuality. It's not just, oh, you do some work and we'll pay you for it, therefore there's mutual obligations. It has to go a bit beyond that. And I think that this point around, are you obliged to accept additional work? That's the key consideration. There's an interesting blog that I've found on this from Con Kelly, who's a barrister, who that link there. So if you're interested in this, you can read a bit more about that there. And another thing that I often think about is, we all know that there's been this case making its way through the whole court system around two Uber drivers, and are they self-employed or not self-employed? That's probably the safest way to say it. And if they're not self-employed, they should be given greater rights than they have at the moment. Now, Uber has lost at every stage, and they were in the Supreme Court a few months ago, and we're waiting for the judgment on that. Could be out any minute. I keep on saying that. I don't know where we are with it. I wonder whether this will become a key consideration for the Supreme Court, mutuality of obligation, because an Uber driver isn't really obliged to do any work. They can just turn off the app and go home whenever they want to. And I think that's one of the sort of key things for them to consider. But we shall see how they decide. Whatever the Supreme Court come to, I'm sure will be very well considered. HMRC, as I say, take this extreme view. They say where work is provided and remuneration is paid, HMRC will assume that there is mutuality of obligation. So in other words, in any time there's a contract, anytime anyone's doing any work for someone else, those conditions will be met. So they say we don't even have to test for mutuality because it's just always there. And this is why they justify the absence of any checks on mutuality in the CES tool, which I am going to talk about a bit later on. HMRC say it's a different thing when we're considering employment status, but for tax purposes, we're only interested in what's happening once the money's been earned. So we're looking at that period of time while the money's been earned, not what happens when someone's not working and whether there's obligations there, such as the Uber driver who has decided to turn off their app. Are they obliged to turn the app back on at some point? That would be something to consider for employment status, but not for tax status, HMRC say. I know this is quite complicated, but broadly speaking, HMRC are only interested in when the money's earned, because that's how you pay the tax. However, I'm not so sure about that. I think there's a point there. It's an interesting thing to consider, but our view still goes back to the fact that they are they've taken an extreme view on that. That's not in keeping with a lot of what the courts are saying. The obligation to offer work outside the terms of the contracts is irrelevant to the question of whether there is mutual obligations during an engagement. That's the point I was making before. That's how they see it. That's what they say in the employment status guidance. And they might have to change that if they lose a case, which I thought I was coming on to next, but I'm not. This is an old case. This is a judge who backed up our view on this. And as you can see, what they're saying there is, look, there's always some sort of mutuality, but that can't by itself automatically mean that the relationship is a contract of employment. It could perfectly well be a contract for freelance services. So this backs up our view, and we often point back to this case. Here's a live case, and this one's really interesting. Everyone refers to this as the referee's case, but PGMOL actually stands for Professional Game Match Officials Limited. And this is about a bunch of referees and how they are paid. And an so there was a first tier tribunal, IR35 tribunal found in favour of the referees against HMRC. and then the upper tribe, and then HMRC appealed it. It went to the upper tribunal. So we're now getting a bit more serious, and this should be setting precedent. And they said there, we do not accept that a contract which provides merely that a worker will be paid for such work as he or she performs contains the necessary mutuality of obligation to render it a contract of service. That phrase, contract of service, that means employment. A contract for services is not an employment. So you often hear that in the legal speak. Is it a contract of service or is it a contract for services? Now, HMRC is appealing to the Court of Appeal. The last time I spoke to someone at HMRC about this, they said that we believe the judge has erred. Well, that could be your view. I mean, technically, because this was a upper tribunal decision, they should now be taking this on board. They should be changing their guidance. They should be changing the cesspool, but they're sticking to their guns and appealing it further. I don't know when we're going to hear that this new case or the appeal at the Court of the Appeal, but they have appealed. It is going to happen, and everyone's keeping a close eye on this one because it's getting quite serious now, going up to the Court of Appeal. After that, it's the Supreme Court, and who knows, if HMRC lose here, they may go on to that as well. So we really will then get a much better understanding of what on earth we mean by mutuality of obligation. Okay. Supervision, direction and control. This one's slightly more easy to understand the mutuality of obligation, but actually you can still argue it out and it still can get difficult. So you hear lots of phrases in the, I think this goes back to ready-mix concrete as well. You get this master-servant relationship thing where an employee is the servant and the employer is the master. It all sounds very archaic, but we know what they mean. What they're saying is that if you're an employee, you really do get bossed around. You know, you have a boss who bosses you about. But if you're an independent professional, you shouldn't say, I've got a boss. You should say, I've got a client contact. The task is set by the client and how you deliver it is up to you. That's probably the best way of thinking about control. There are ways you can break this down. So you can think about, is it how the work is done? Or is it what work is done, or where the work is done, or even when the work is done? You know, as an employee, in my contract, it says I have to work certain hours. You know, that's the way that it is. Now, yes, maybe I've got a flexible employer who I can say, you know, I'm going to make up some hours that I missed out on this morning when I popped off to take my kid to the doctors or whatever, and I'll work a bit this evening. But generally speaking, you know, I am expected to work certain hours. Working from home is considered to be a bit of a pointer away. You know, I'm not really controlled, so I work from home a lot. That's slightly, I think that's going to be pretty strongly diminished after the year we've just had where everyone's working from home. There's lots of employees are working from home, and because of modern technology, it doesn't mean you can still be very closely controlled whilst also working from home. But it could be a helpful pointer. Choosing your own hours could be a helpful pointer. But I think that the main one is how you do the work. The task is set, how you deliver it is up to you. If you have control over that, I think that demonstrates a serious lack of supervision, direction and control, which points away from IR35. An interesting thing about control is that Matthew Taylor, who did a review of modern working practices, published that a couple of years ago, is quite influential, and we're still talking about it now, and the government is still supposed to be doing actually implementing some of the recommendations in that, but they haven't got around to it because of Brexit and COVID and God knows what else. He said we should place more emphasis on control. This is where it's at. This is how we should decide whether someone is truly self-employed or not, is to think about the control element. And also another interesting thing to point about, another place where I think HMRC are being really cheeky is that, you know, I would argue that if you have someone who is a brain surgeon and they're a self-employed brain surgeon and they go around different hospitals as a locum doctor performing this incredibly complex surgery, they are not controlled because they are the experts and they are highly skilled and no one else can tell them what to do. You can't have some, you know, manager from the hospital coming in and telling them how to perform the brain surgery. It's up to them. HMRC would say that that doesn't demonstrate a lack of SDC or supervision, direction and control, because the work is so highly skilled we can't even consider this test. and therefore this does not point away from IR35. Whereas I would say that's nonsense. You know, you're not, either you're controlled or you're not, and if you're not controlled, then it's a pointer away from IR35. Okay, now, just before I get onto these other factors, the thing about those first three are that ready-mix concrete found that in order for it to be an employment, and for our purposes, in order for us to establish that IR35 should apply, all three of those conditions have to be met. In other words, if you can knock out one of those, IR35 doesn't apply. So you may not be able to send a substitute, and if we can work out what it means, we might all agree there are mutual obligations, but you're not controlled in how you do your work, IR35 doesn't apply. And the same goes for any one of them. In reality, a tribunal will look at the whole thing. They talk about putting the pieces together, standing back and looking at the whole picture. And all of it will influence the other to a degree. But technically, it is the case that if any one of those things isn't there, IR35 doesn't apply. Okay, other factors. So these are secondary factors. They're often known as the business on own account tests. These are not as important as the first three, but they will be considered as well. And if the first three aren't that clear, they will come back to these ones to think, and this could swing it. Essentially, what they want to know is the worker, the individual, in business on their own account? Or are they just carrying, an employee is not in business on their own account. But if we can establish that the worker does demonstrate sort of characteristics and signs of being in business, then IR35 doesn't apply. Now, Kay Adams, the name that you can see at the top there, she is best known as one of ITV's Loose Women on the show Loose Women. But she also has had a show on the BBC called The Kay Adams Show. And HMRC took her to tribunal for her work with the BBC and on the Kay Adams Show. And they said, look, you know, Kay Adams can't send a substitute because it's called the Kay Adams Show. There probably are mutual obligations going on here. And, you know, control is a bit, you know, the BBC controls some of it, she controls some of it. But they said that IR35 did not apply because she was in business and on her own account, because she's clearly got this other work, notably with the ITV for Loose Women. And so they said, you know, looking at the whole thing, we just think Karen's in business and therefore IR35 doesn't apply. Now, that's a really interesting judgment because it goes against what I said at the beginning, this idea of it's on an engagement by an engagement basis. So, you know, I would say, well, you could still be caught IR35 for the BBC, and your work with ITV is something totally separate that shouldn't be considered in that engagement. But here, the tribunal did look at that, and it became determinative in the outcome. Now, HMRC, unsurprisingly, are appealing that one as well. And I'm not quite sure where we are with that, but I would have thought by now, I think probably because of COVID, we haven't had that, because that's been old news that they were going to appeal that one. So we'll see what the upper tribunal has to say about that. But it's quite an interesting case. I'll whiz through these other ones. Part and parcel of the organisation. In other words, are you part and parcel of the client organisation? Are you part of the fabric of that organisation? If you are, it's more likely that IR35 applies. If you're not, if you're very much detached from it, then you know you're probably in business on your own account. This is where we get into length of time. You know, if your engagement has gone on for a few months, then you're probably not part and parcel of an organisation. If you're an employee for a few months, you're probably not part and parcel of an organisation. But if you've been working there for 10 years, then you're more likely to be. However, you can work in an engagement for an indefinite amount of time. There is no length of time that says once you tick over a certain amount, IR35 applies. It doesn't work like that. You go back to looking at the ready-mix concrete factors. However, let's face it, we all know that it begins to look harder and harder to justify that IR35 should not apply if someone's been in engagement for a very, very long time. And, you know, technically you can get, and I will still go ahead and argue the case. I could go and argue that someone's outside of IR35, even if they've been there for 20 years, but I know that I'm up against it because to the outside world, it looks like what you're like an employee. Financial risk, do you take on financial risk? You might not get paid. Do you have to buy equipment, that sort of thing? Do you attend training and team meetings and team building exercises in the mud along with all the other employees? If you do, then it looks like you're an employee and IR35 might be more likely to apply. Do you have access to facilities like the car park or the canteen? And did you go to the Christmas party? This is the one that when I first started working at PCG, as it was then 10 years ago, and I didn't know anything about IR35, I was trying to get my head around all this stuff, and someone said to me, well, if you go to the Christmas party, then IR35 applies, you know. And I said, that's it. You just don't go to the Christmas party and you're fine. But actually, I don't think it's ever come up in any case, in any of the case law that I've read anyway. I've never noticed it being a factor that's ever been discussed that someone went to the Christmas party. But you know what they're getting at. You, as a contractor, you do want to draw a line. You're not an employee. You're more like Steve and Bob, who are doing our water cooling servicing that I talked about earlier. Yeah, Steve and Bob aren't coming to our Christmas party, right? You know, it would be weird if they did. So you want to be like that. You want to be a bit detached. It helps. Okay. I know I'm going through quite quickly. I said I'd come back to office holders. A few years ago, these rules changed. It was about 2012, and it came about because there was one senior guy working for the student loans company called Ed Lester, who it was discovered was working through his own limited company and being paid in that way. And lots of people felt that he shouldn't be, because he was the CEO of a very senior, of a public sector organization, and shouldn't be being paid in a way that could construe a tax advantage. He was also being paid, you know, very well, like CEOs tend to. And so, you know, there was quite a big difference in the total tax that was paid over because of the way he was structuring and they were structuring those affairs. So they said any office holder should be on the payroll, basically. IR35 applies. An office holder is a permanent substantive position which had an existence independent from the person who filled it, which went on and was filled in succession by successive holders. Now, I think that's about as clear as mud. I think you could apply that to a cleaner, and we're not talking about cleaners here. We're talking about really senior people. I think the question marks come over CEOs and CFOs and people like that. I think that you can argue you can have an interim CEO. I think that they don't necessarily have to be on the payroll, but I think that this office holder thing gets a bit shady on it. I think executive directors, board members, company secretaries, that there we have that they should not be. They should be on the payroll. Basically, the IR35 applies is essentially the way that those rules work. I think I'm getting towards the end of it now, so bear with me. Check employment status for tax. So as many of you will know, this is the online tool which HMRC brought out to help originally public sector clients work out whether IR35 should apply or not, because they changed the rules in April 2017 for public sector engagements. And they said, from now on, clients are going to decide whether IR35 applies or not. They're the ones that are going to be held responsible for making that decision, and contractors won't do anymore. So they brought out this tool. It is a voluntary tool. It's online. You can go and see it. No one has to use it, and if you do use it, it's anonymous. So no one knows. If you want to go and have a look at it and click around and put your details in and see what it gives you, no one's going to know. Your name doesn't go into it. HMRC say that it gives a definitive result 85% of the time. They actually changed this. If you look at the bottom bullet point there, there was a second version of this launched last year, a year ago. And I think that that percentage has gone down. I think then you now get a higher degree of we're not sure. From the information you put in here, we still don't know if IR35 applies or not, which makes it, you know, kind of a bit useless. Our main problem with it, though, is that it doesn't match the case law. The stuff that I've just whizzed you through here, it doesn't go into that. And what it doesn't do is talk about mutuality of obligation at all. It doesn't ask any questions around that. And as I said, it's because HMRC say we don't have to test for that because it's always there because there's a contract. Excuse me, I'm just gonna have a swig of water. And this is the big problem with the assess tool. I actually think that it's become totally discredited now, the assess tool. I mean, every expert under the sun has said that this doesn't really work very well, this tool. And so as we push towards April next year, and unless there's a sort of small miracle, those rules are going to come in. You know, we are still pushing against it, but we must prepare for those rules to come into place. I think that there's a very strong case that contractors can make to their clients and say, don't use the CES tool. It's discredited. No one thinks it gives accurate determinations, and your contractor workforce is going to feel really put out if you use this. I'm speaking at a event this afternoon that Grant Thornton's have organised. There's going to be about 400 or 500 clients there, I think, all different kinds of clients. And I'm going to be saying exactly this to them. I'm going to be saying, the CES tools, contractors don't believe in it, experts don't believe in it. It's not the way to do your assessments. So I'm trying to, get clients to understand that this tool is no good. And the reason why I don't like it is because I think that it's basically biased. I think that either you're going to get a determination which says that you can't tell, or you're going to get a determination which says you're inside IR35. This is the key question. I've been through the tool several times and used different permeations of answers. It asks you about, I think we're now on about 25 questions or something. But there's a question which comes up. It's about the 7th or 8th question that you get, and it's this one. Now, this is how it's worded if you are the client. So I've gone in saying, I'm a client, I want to assess someone's status, and these are the questions I get. This question, which is a direct screen grab, as you can probably tell from the crude sort of print screen thing that I've done to put it into the site, this is a screen grab from the tool itself. And I think that if the client says, yes, I have the right to reject a substitute, then it is very unlikely that despite whatever you put in the subsequent questions or the ones before it, that it's going to come out and say IR35 does not apply. In fact, I've never managed to get it to happen. I have managed to get it to say it can't tell. So I've answered this one. I've said client has a right to reject a substitute. And I've answered every other question in the best way I possibly can, knowing what I know about IR35 to try and get that person outside of IR35 at the end of it. And I haven't managed it. And that's not the way the IR35 rules work. There is far too much weight put on this question. And also, if we look at the wording of this question, do you have a right to reject a substitute? A substitute is someone the worker sends in their place to do their role. This can include rejecting a substitute even if they are equally qualified and meet your interviewing, vetting, and security clearance procedures. So they've worded that a bit of a peculiar way round. They're trying to get round the fact that we know that you have a right to ensure that a substitute is equally qualified and meets your interviewing, vetting, and security clearance procedures. You should consider this outside of that. The way they've said it, this can include rejecting it even if they do that. So I find the wording of this wrong, and I think that it's unlikely that a client is going to understand all of this and tick no, because I think that a client is going to say, well, of course I've got a right to reject a substitute. They could send a lunatic in. Well, in fact, that means that they're not equally qualified and they don't meet our vetting procedures. So, but the way that they've worded that, is not right for me, and it means that very often a client is going to say, yes, of course I have a right to reject a substitute if they're a lunatic, and therefore we go on and look, IR35 applies. Okay, how are we doing for time here? I'm really prattling on, I'm sorry. Okay, thankfully that's it. That's the end of the slides. There's a couple of links there so you can stay up to date and send us in subsequent questions to that email address. Maybe Ryan can join us again, who hopefully has been monitoring questions, and let us know if there's been any good ones. Or I'm sure.
Yeah.
Let us know.
Yeah, there's been loads, actually, some really rich questions, and actually some really nice feedback from people saying, I think it might have been Andrew, called it a breath of fresh air. It's quite a clear explanation of some of these issues, and you have been talking about doing this for a very long time, Andy, pretty much the whole summer. So. Yeah,
we keep on doing IR35 webinars, which are all about the changing the rules and what's a contracted out service, and small company exemption and all of that. And that's all very important. And I keep on saying, we're not going to talk about how we determine status today. I will do a webinar about this later on. So I have been promising this webinar for a while.
Also, the slides, you'll get the slides, and we have an IR35 hub on the website, and all the information will be available there as well. But you'll get the slides emailed to you. Shall we crack on some questions?
Can I just, I think you get the recording. I'm not I think there might be a problem getting people the actual slides because of the way that we can attach things in the software. But hopefully you'll get the slides and you will get the recording. Yeah, we will try and get the slides out as well.
So we've had some quite interesting questions very quickly, because I think Sue came up and said, can you maybe either re-explain, I don't know if she missed the original explanation of Moo, just very quickly touch on Moo again, because I think you've spoken about it so much that just a little reminder.
So Sue, it is the most difficult aspect of this really difficult thing of IR35 status, and it's the most contested and everyone argues about it. But broadly speaking, what I think where most people would say it, and the courts mostly back this up, is that it's about an obligation to perform work and an obligation to provide work. So is the client under an obligation to provide work to a contractor? And is the contractor under an obligation to perform work or do the work if they're offered it? But of course, if you've got a contract to do something, then there are obligations within that contract. But what happens, for example, if, so one example that I've heard of, which helps to explain this a bit, is imagine a bank where you've got 100 people working and there's 80 employees and 20 contractors, and all the systems go down at lunchtime so that people can't log on and do their work. The contractors cannot do what's in their contract to do. Now, the employees are expected to stay behind for the rest of the day and do some filing or catch up on some meetings or do whatever else they have to do. They don't just get told you can go home. But the contractors go home because they can't do what they're supposed to be able to do. They're not under an obligation to hang around and do something else. It doesn't work like that. So there's a difference you see in how an employee might be treated in that sort of scenario to how a contractor might be treated. And that's one way to think about it. Another way to think about it is if you've completed the work that's in your contract to do, and the client says, we really need you to do this other thing now, you can say to them no. Whereas an employee can't. I mean, I'm an employee. If I've done this webinar, which I'm supposed to be doing, and then the CEO rings me up and says, well, I now need you to do this thing, I have to do it. I have to keep on doing what my employer wants me to do, whatever that is. And that can change over time, but it's different as a contractor. So that's what mutuality of obligation is really all about. But as I say, where we're arguing about it is because HMRC say, if you as a contractor are obliged to do the work, which it says in your contract that you have to do, and the client is obliged to pay you, then that's mutuality of obligation. And I believe that that is quite an extreme view, and it is being rebuffed at the courts, particularly in that referee's case. That's a really interesting one to keep an eye on. We will certainly be following it closely when it gets to the Court of Appeal to see what they have to say about this.
So, following on from that, I think that's actually quite concise considering. Kevin has asked a couple of quite interesting questions, two around Moo. I'm going to try and answer them fairly quickly, but he's given two examples. So, in financial services, often you might have enforced leave, say for COVID or going home for the Christmas period because of some sort of issue or lockdown or something. Does that demonstrate Moo? And then a second one, what happens if there's rate reduction? Does that show in control? Does that prove that Moo doesn't exist in that engagement? So rate reduction and like being the office shutting.
Yeah, I mean the office shutting is a bit like the thing that I just said before about if suddenly you don't have to work anymore, that's it, and you won't get paid either. In the way that it should work is, oh, sorry, the conditions are no longer available for you to do that work. You can now go off and do whatever the hell you want to do, and we're not going to pay you because you're not doing the work for us. Rate reduction, I'm not sure that a rate reduction necessarily demonstrates a lack of Moo. I wouldn't get too carried away with that idea unless you could build a complex legal argument around that, why that should be the case, and someone probably can. I'm not convinced that there's a route from that to demonstrate there isn't Moo.
Okay, how about, so we've had a lot of questions stream in just now. So in terms of substitution, right, again, another issue. Do you need to as long as it's in the contract that you can send a substitute, is that the important thing? It doesn't necessarily matter if you do at some point send a substitute in.
So the important thing is, as I said at the start, that it should be in the contract, but also that should be reflected in the real arrangements. So HMRC believe, and possibly they're sort of right about this, that everyone puts in a substitution clause into their contract, and they would say with a sort of a nudge and a wink between the client and the contractor, saying that we'll never really use this. It's just got to be in there so that, you know, if anyone looks, it doesn't look like this is an employment. But the way that it works is you should have a right to substitute, and it should be a real right. You don't have to use that right in order for it to apply, but it should be real. And if HMRC were to go and quiz the client and say, look, would you really accept it if Ryan Barnett sent in a substitute next week? They should be able to say, yeah, no, we would, yeah, we understand that, you know, we have a contract for Ryan Barnett Limited to supply certain services, and we don't really mind if Ryan provides those services or someone else, as long as they're suitably qualified to do it. That's how it should work. Well, and one final thing on substitution, it's quite important that the payments don't go directly between the client or agency and the substitute. The payment should flow through you. So it should be your company that receives the payment from the client, even if you haven't done the work, and then your company pays the substitute. That way it demonstrates how that's working, if you see what I mean.
Jeff has pointed out the issue around blanket assessments. Now, us at IPSE, we've come across a lot of firms doing this, particularly towards the end of last year, and then obviously before the delay, of very large companies that hire a lot of contractors, just saying either everyone's in IR35 or the alternative, which is we're not going to hire contractors anymore. And he's asking, is there any sort of tangible negative outcome on the client at the end? Does this action point to the IR35 legislation failing to be applied correctly? And basically, will there be any kind of, you know, knock-on effects to that, do you think?
Yeah, so blanket assessments, it's a problem. It was a problem in the public sector when these rules came in there. You look at what happened in the NHS. So NHS Improvement, which is like an overseeing body for all the NHS trusts, sent out some guidance when the rules first came out and said, from now on, everyone's inside IR35. That's it. That's how you should treat this problem. And a bunch of doctors, locum doctors, got together and formed a group, engaged the services of a barrister, and that barrister launched a pre-action protocol for a judicial review against NHS Improvement, saying that you are going against the rules here. There is this provision in the new legislation called reasonable care. In order for a client to discharge its obligations under the new rules, they have to not only make a decision and then inform other parties of that decision and inform them how they came to that decision, but they have to take reasonable care when they come to making that decision. And so doing a blanket assessment, in other words, saying everyone's caught by IR35 from now on, is clearly not taking reasonable care. The problem is, as the question picked up on, is HMRC actually going to go after a client who does that? You know, is HMRC going to say, oh, I see that you've put all your contractors onto the payroll now, good boy, well done, and move on to the next one? And that is our big concern as well. How much teeth does this reasonable care provision actually have? There's another type of blanketing as well, which is blanket banning of contractors. This is where clients say, God, this IR35 stuff looks like a nightmare, don't want to deal with it, I don't understand it, and I don't want to get into trouble with HMRC, so we're just not going to use contractors anymore. Anyone who wants to come and work for us just has to automatically either be on our payroll or be on maybe an umbrella company payroll. Now, unfortunately, that's a way of them sidestepping all of this stuff. And unfortunately, that's not illegal, or there's nothing wrong with it. A company can decide not to engage certain types of people. But I do believe that although we did see evidence of that, particularly in the financial services sector, when we thought these rules were coming in this April, I believe that they're reversing from that position because they're realizing that they need contractors. There's a commercial need for it. And I think my hope is, and the reason why we're going out and speaking at Grant Thornton's today, is so that to try and get clients to understand, look, you can get your head around this, and you can engage a contractor, and you can engage them outside of IR35. You just have to get everything in order. Essentially, if you want an employee, employ them. If you want a contractor, engage them on that basis and put it outside of IR35. That's where I'd like to see us getting to.
A couple of people have pointed out the office holders that you mentioned earlier, and that's something I know we haven't covered a lot of times in previous webinars. And a couple of people have raised the question of non-exec directors. Do they come under IR35? And attached to that, what if can they be sole traders? And then how would that work?
No, they're supposed to be on the payroll of the organisation that they're in, if they're an office holder. So if you're an office holder of what we would call the client organisation, the ultimate person that the worker is providing those services for, if you're an office holder there, then you must be on their payroll. That's how it should work. Now, exactly what is an office holder, and can you have a non-exec director who could make the case where you're not really an office holder? I think the rules are pretty unclear myself. Some people disagree with that and say they're perfectly clear, it's all very obvious. But if you read, that slide I had a minute ago with the where I explain what HMRC's version of this is, I'll find it. Have I gone too far? Yeah, this one. I'm just not sure that convincingly explains what an office holder is. There is guidance on gov.uk about what an office holder is, and they do talk a lot about board directors, company secretaries. They talk about that. Where it is definitely unclear, and possibly because they're not automatically office holders, is interim CEOs and things like that. But they are often mentioned in the articles of the organisation, and therefore you begin to think, well, is this an office holder? Who knows? We may get a case on this at some stage. It'd be quite interesting if we did. But I think for the time being, you can be an interim CEO and not be on the payroll. I believe.
So we've got a few minutes left. If anyone wants to fire in something, we maybe can answer a bit quickly. But
I saw one I want to get to actually, Ryan, from Lindsay, who said, and I've now lost it, but he said, look, big change next April. Are HMRC still currently launching investigations against contractors? Yes, they are, Lindsay. They are. They've been really going after TV presenters lately. So that Cairns one, we've had Eamon Holmes, we've had Paul Huckabee, who's a TalkSport presenter. We've had Lorraine Kelly, who won her case. It was a real big one. They were after about 1.2 million quid there. They are still launching cases, and they're still pursuing these referees. So that's going up through the courts right now. So they are still doing it. The thing to look out for is that you as a contractor are liable for the previous 6 years of your engagements. So any engagement that you had in the last 6 years, HMRC could come along and say, did you consider IR35 while you were working in that engagement? And then you find yourself inside an investigation, ultimately, possibly at a tribunal. Hopefully you're an IPSE member, and IPSE would back you up if that ever happened. You still have that liability even after the rules changed. They could still come after you. Now, they have said things like, oh, we're not focused on that, we just want everyone to be compliant with the new rules. But they did say that in the public sector too, when the change came in there, and that didn't really happen then. And we pushed HMRC then, and we pushed them now for a what do you call it, an amnesty. Is that what I mean? Is that what I mean? To sort of just say, like, forget about the past. We definitely won't come after you. You're absolved from anything that you may or may not have done back then. Let's look forward. But they didn't do it then, and they haven't done it now, and people are still liable. So, you want to make sure that your engagements that you've had previously and the engagement that you're in now, you've got a good contract, you can get your contract reviewed, and also that you've got some insurance backing you up should HMRC ever come knocking, because you will want some professional help if that ever happens. And if you're an IPSE member, you've already got it.
So maybe one final question, because a few people were pointed towards it. Tony, Michael, Russell have all asked about we've got what, 5 months left in theory until this comes in. And there's a lot of roles out there being advertised as either inside or outside IR35 now, and potentially changing. And it's a bit of an open question, Andy, but should we be asking clients, you know, what assessment's been done? Is it okay for them to announce that it's definitely inside IR35 now? They're probably just covering their backs, really, if I'm honest. Do you have any thoughts on that? I don't know, because it's quite a strange period as a contractor to try and engage in the market at the moment because of it.
Yeah. So there's going to be this really difficult period where you've got engagements which are going to cross over from the current rules to the new rules. And then there'll be a decision about, you know, you may have been happily going along inside this engagement. You've had your contract reviewed, you're pretty satisfied, you're watching these kind of webinars, you're satisfied that your engagement is not inside IR35. The client's going to come along at some point and possibly say, well, we've decided that from April it is caught by IR35, and you're going to disagree with that. You're also going to be worried that HMRC might say, well, hang on a minute, if you accepted that in April, that your engagement is caught by IR35, how come you weren't applying IR35 yourself when you had the liability for that? I think that that's where we found in the public sector lots of people terminated their engagement. I'm not saying that that's what people should do, but that's obviously the sort of the nuclear option. It should say, I don't accept your IR35 decision, and I'm going to walk away from it. What can you be doing now to help? Well, I think that it's a good idea if you're planning to, if you're in an engagement now, which is set to run over April, and if your client hasn't yet said anything to you about it, I think it's a good idea for you to approach them and say to them, look, these rules are coming up. We know you're going to have to make a big decision. I'm a contractor. I know about IR35. I've been dealing with it for the last however many years. And I'm satisfied that IR35 doesn't apply to this engagement. I've got my contract here. It's been reviewed. Here's the opinion on that. You could set it out in a letter and say, for all these reasons, I'm not controlled in the way I do my work. I have a right to send a substitute, whatever it is that you think that could help you, and sort of get in front of this thing with them. Now, they now have to, the new thing is, they didn't have to do this in the public sector. If you can also challenge a decision, because they now have to explain to you personally what their IR35 decision is. And you can go back to them and say, look, I think you've got this wrong. I'm going to challenge it. And they have to consider your challenge, and they have 45 days to get back to you. Now, they don't have to do much beyond that. There's nothing to really say that, you know, they can't just turn around and say, yeah, we've considered your challenge and we still think we're right. But I am hearing that a lot of clients who want to try and manage this responsibly are then taking that on board, or perhaps going to external people and getting them to give a determination or to give their view on whether IR35 should apply. So it's definitely worth getting your ducks in a line on this one and working out what are the arguments that show that you're outside of IR35 and presenting those in the clearest way possible to your clients. I don't know if that really answered the question.
I think it did, and I think you know, as we draw to a close, you know, Andy, there's loads of information on the website, isn't there? We've got the hub, and we're kind of going through a process of sort of updating it. Sue, for instance, just pointed out, would there be a way of us producing something that was very clear and concise to read about how status is determined? There's been a couple of questions about guidance.
Yeah, we do have a guide to IR35 with all this in it. It's quite, so we've got a couple of guides. We've got sort of an old guide which goes into lots of detail on all this stuff. Possibly, you know, a bit too long, you could argue. Our more current guide on our IR35 hub does talk about all this pretty clearly, and you can go on there and have a look. So hopefully that will be useful to you. Also, I just want to say that I've had a text message saying that we can send the slides separately when we're requested to by an IPSE member. So if you email into policy queries and say, hi, can you send the slides, we can do that. Otherwise, we will add all the links that were in this presentation to an email that you will all be sent along with a feedback form for the webinar as well. And it will also include a recording of the webinar. It's just attaching a slide deck to that is we're restricted by the way the software works, unfortunately. Okay. Thanks very much, everyone. I'm going to go through all of your questions afterwards, because I know we haven't had as much time as I wanted to, because I've waffled on too long. But hopefully that's been helpful, and I'm going to look through all the questions. I might put together a blog piece or something off the back of this one, kind of addressing some of the unanswered questions. And we will be doing more of these IR35 webinars as well, particularly in the run-up to April. So I don't know if we have any scheduled for later this year. We're beginning to run out of Thursdays, aren't we? But we certainly are. We'll be doing some more in the new year as well. Thanks very much. Bye.
Cheers.